Last name is spelled Matiasic. The California Constitution in Section 28, Subpart F1, provides that all students in the state of California have a, quote, inalienable right to attend campuses that are safe, secure, and that are peaceful. Unfortunately, for the last 20 years, the students at Yuba City High School have been denied their constitutional inalienable right because they have been subject to the predatory behavior of Jim Whittaker that has been countenanced by the school district. Today we are here to announce that we have taken the first step towards the path of civil justice on behalf of our client, a 14-year-old innocent victim of Jim Whittaker who was sexually abused by her PE teacher. Specifically, the lawsuit names 4 defendants. 1, the Yuba City Unified School District. Number 2, the current superintendent, Doreen Osumi. Number 3, the former superintendent, Nancy Auberg. And number 4, of course, Jim Whittaker. Jim Whittaker's injurious, gratuitous, sexually deviant conduct perpetrated upon students has been well chronicled in the media. Unfortunately, this cancer that is invading this particular school district is not limited to Jim Whittaker. In fact, it is a problem that's endemic to the district as a whole. When children are allowed to be preyed upon, when you provide an environment for predators to prey, that's precisely what they're going to do. Crimes against our most vulnerable, the children whom we send to school, are crimes of a most egregious nature. But what makes it even more disturbing in this case is that this crime could have been and should have been prevented. There's a doctrine in the law called in loco parentis. And what that means is when we send our children to school, the teachers, the superintendent, the administrators, they stand in the shoes of these children's parents. They are charged with safeguarding our children's well-being, including their physical well-being. Here, the Yuba City Unified School District abandoned their obligations in loco parentis and threw these students to the wolf that was Jim Whittaker. At a time when they should have been sounding the alarm, the administrators of this school district stuck their head in the sand. At a time when they should have been calling the police, they turned a blind eye. Specific complaints by students and their parents were made to managing agents of the district at the highest level, including to the current superintendent. Yet these administrators failed to act. And as a result, countless additional victims, including my client, were sexually abused at the hands of Jim Whittaker, and needlessly so. The actions of the district make them complicit in the sexual misconduct perpetrated by Jim Whittaker. Make no mistake about it, this is not some type of mere inaction on the part of the school district. There's more affirmative misconduct here. This is not nonfeasance, it is misfeasance. It is malfeasance. It is criminal in nature. And in fact, California Penal Code Section 11166 obligates our teachers, our principals, our superintendents to engage in what is called mandatory reporting. They are mandated reporters. And what that means is, if any one of these educators has a reasonable suspicion that a student was subjected to any type of abuse or neglect, including sexual abuse, they are obligated to contact the authorities. Failure to discharge your duties as a mandatory reporter is a crime. It is a misdemeanor subject to punishment by 6 months in jail or a $1,000 fine. Today we are calling on the local district attorney to open an investigation into the teachers and administrators at the Yuba City Unified School District who failed to discharge their duties as mandatory reporters under Penal Code Section 11166. And there is precedent for such an investigation and prosecution. Indeed, in 2012, the principal at O.B. Whaley School in Evergreen School District in San Jose named Lynn Vijayendran was tried and convicted by a jury of her peers for failing to discharge her duties as a mandatory reporter. We are calling for the same type of investigation and action in the instant case. On behalf of 20 years worth of students, we are calling for change. The district in this case, as set forth in our lawsuit, had specific knowledge that Jim Whittaker had a propensity to engage in assaultive and sexually abusive conduct, yet they did nothing. They continued to employ Jim Whittaker. They failed to warn parents about Jim Whittaker's propensities, and they failed to warn the students of Jim Whittaker's propensities. As a result, additional students were abused, and under the law, the school district thereby authorized, ratified, and condoned Jim Whittaker's behavior. On behalf of all the victims of Jim Whittaker, on behalf of all the victims' parents, and on behalf of the community, we are here to say enough is enough. It is our fervent hope that our action here today is the first step towards a sweeping change at the school district so that no child sent to school to learn is subjected to sexual abuse in this district ever again. Thank you for attending, and we're open to any questions you may have.
Was the case in question referred to the police department directly?
So there has been a law enforcement investigation as a result of what's going on, and has been turned over to the Attorney General's office, who's currently investigating.
That case has not been sent back from the Attorney General's?
My understanding is that it's still under review by the Attorney General's office.
What is the family seeking?
A few different things. I mean, number one, we're seeking monetary compensation for the damages suffered by our client. The pervasive tentacles of being a victim of sexual abuse are profound. They are lifelong and they are life-altering. And so we are seeking monetary compensation for therapy, for the pain and suffering and emotional distress attendant to the injuries she sustained. But our goal by way of the lawsuit is multifold. It's not just about monetary compensation. We are also seeking sweeping policy changes in the district so that a policy and practice is put in place to prevent this type of misconduct from going forward again.
Given the research that you've done putting this suit together, is it your belief that they just didn't care about this behavior, didn't think it rose to a level of needing to have some action taken? Or what's your opinion of the district's behavior to this moment?
My opinion is that the behavior has been despicable. When we talk about, they are all trained on their duties as mandatory reporters. In order to report something, it doesn't have to be a certainty that it occurred. The standard is not beyond a reasonable doubt like you see in a criminal case. The standard is merely, was there a reasonable suspicion that something happened? When you have students coming in and speaking with administrators, and parents of those students coming in and speaking to administrators, including the current superintendent, saying, "This is what Jim Whittaker did to my daughter," that rises to the level of reasonable suspicion. And so I'll let them answer for themselves as to why they didn't perform their duties as mandatory reporters, as to why they condoned, authorized, and ratified his conduct. But as I said earlier, we believe that they are complicit in the activities of Mr. Whittaker, both morally and from a legal perspective.
In your time as an attorney, have you seen something that you feel is as pervasive or long-lasting in a particular educational system?
In terms of the egregiousness of the misconduct, the case that comes to mind is the one that I previously mentioned and that I was involved with at the Evergreen School District in San Jose. But in terms of the duration of the misconduct by the perpetrator, it was relegated to a few years. I have never seen a situation where a predator such as Jim Whittaker was allowed to prey for the better part of 20 years. When I say that this problem is endemic to the district, it's endemic as evinced by the fact that it happened over the course of 20 years. It's not just an administrator recently who fell down on the job. This particular person, and I don't know if it's because of his political connections or his standing in the community or the fact that he's a supervisor, or as to why he was treated differently than any other sexual predator. But he shouldn't have been allowed to pray.
Can you briefly talk about the individual standing behind you and why they're here?
Sure. We have members of the community here today, and I think it's reflective of the fact that while this lawsuit obviously is about our 14-year-old innocent victim, the most recent victim of Jim Whittaker, she's not the only victim of Jim Whittaker. This community has been victimized for the better part of 20 years by Jim Whittaker, and the fact that you have a number of people who took time out of their day to come here and stand here and show support is indicative of the fact that it's not just us calling for change, it's the community calling for change. And when we say enough is enough, I know I'm speaking on behalf of the entire community and all those parents who send their kids off to Yuba City High School hoping that they are going to be safe that day. Any other questions?
Will there be is there any likelihood that there will be other parents that join this lawsuit? Is that a possibility, or would that have to be a separate action?
You know, I think the injuries in each of these cases are so discrete and unique that there would be different lawsuits. But given the number of victims of Jim Whittaker, I wouldn't be at all surprised if we see additional lawsuits coming down the pike. And as set forth in our lawsuit, there were numerous victims of Jim Whittaker over the last 20 years, many of whom do not want to be named publicly and want to remain anonymous, but many of whom have had the bravery as well to step forward and publicly give an account of what happened to them at the hands of this perpetrator.
Have you been in contact with any of those people directly? How many were there, and are any of them planning lawsuits as well?
I have been in contact with many of the victims. Many victims have contacted me, and I can't reveal the contents of those communications because they're protected by the attorney-client privilege, but I would not be surprised to see further lawsuits down the line.
When I asked about the police department investigation that had been referred, who referred the investigation? Was that the district attorney's office, or how did that get referred to the Department of Justice?
Well, ultimately, the local district attorney's office is the one that referred potential consideration of criminal prosecution against Mr. Whittaker to the Attorney General's office, presumably because of the apparent conflict of interest by virtue of his standing as a Sutter County supervisor. Any other questions? And anybody else has anything they want to add? Okay. Thank you very much for coming.
Thank you.